petition refusing the grant of divorce on the ground of cruelty. Lord, I'll just inform that our client is 73 years old and fighting this litigation for 22 years. Classic example, Lord, why this honorable, and according to us, the wife is already remarried, still contesting this. That's it. Marriage is not merely between two individuals. It's also between two families coming together. There are many people involved in the question of marriage, not when the disputes arise. It is actually the families which are affected. Nobody is talking about the mental health of the child and the family members, not in the long definition of rape, by saying that not a rape, whether it is committed even by a husband for a girl who is between 15 to 18, can be still considered as a rape, though that part of the legislation was read out and then it was removed. Lord, I have filed a written submissions.
Okay.
Lordship may kindly take note of that. Yes, Mr. Savla is also. This is a specially petition. Not all other matters are transfer petitions. Mine is arising out of a specially petition, out of a High Court judgment, and it's a specially petition refusing the grant of divorce on the ground of cruelty. Lord, I'll just inform that our client is 73 years old and fighting this litigation for 22 years. Classic example, Lord, why this honorable, and according to us, the wife is already remarried, still contesting this. That's what we filed about. Yes, she's remarried. We filed a voter list. They may be disputing it. Nevertheless, I have filed it along with the SLP as well. I'm just informing. We are not going to merits of the matter today because your lordships are actually determining only the questions of law. Lord, I am not addressing the first issue or the second issue. I am only addressing your lordships on the third issue. However, from where Mr. Giri left on the question of mutual consent, whether your lordships were contemplating about that giving powers to the trial court about dispensing with the 6 months, where Mr. Giri was saying that it can be only exercised by this honorable court. Anyway, it will become redundant because by the time it comes here, unless the trial court is clothed with that power of dispensing with the 6 months, by the time it travels, many of them may not even be able to travel this far, by the time it travels to this honorable court, it is more than 6 years at least, because it goes from stage to the stage. So therefore, the question of only power being exercised by this honorable court and 13B by dispensing with may not be appropriate only to decide about this honorable court. But nevertheless, that issue, I'm not addressing. I'm just pointing out this could be a difficulty in doing that. Now, just two things, your lordships had said in Ashok Hurra, which actually resulted in, while talking about 142, your lordship in fact clothed this honorable court with the power of curative jurisdiction as well, which arose from the Rupa Ashok Hurra, which is from the Ashok Hurra judgment, which was read out in the morning. What was held was a mutual consent was withdrawn later, which resulted in Rupa's judgment, where this honorable court has held that you had the power of even opening a review of a matter under 32, and this read with all these powers, which is granted to this honorable court. You can even reopen a matter which is closed in a review, unless there are new grounds which are not raised, which are already raised in the review, which a certificate is given by a senior advocate. So that is also a consequential effect of powers of this honorable court, how this honorable court can extend its powers. Also, to buttress the point which one of Ms. Jaisingh's points, which I had also noted, is that the parents' patria jurisdiction of this honorable court. Your lordships are not even, like your lordship just now said, marriage is not merely between two individuals. It's also between two families coming together. There are many people involved in the question of marriage, when the disputes arise. It is actually the families which are affected. Nobody is talking about the mental health of the child and the family members in the long run.
Families are affected, but families also
intervene, but subsequently what happens, the product of marriage, the child will not, most of the circumstances, most of the cases, there is a child.
That is always so.
Yes, so therefore, in the interest of the child also, your lordships has gone to the extent of saying, in a case where twins were there, and they were inseparable twins, where there was a PAL brought to this honorable court, parents were refusing to separate the twins. Of course, there was no medical board was ordered here. Parents did not advise, did not go in favor of that. Some good Samaritan approached this honorable court under 32, and it's a reported judgment, in 2013. This honorable court would say, even if the parents are opposing, if it comes to the welfare of the child, this court, in its parents' patria jurisdiction, will go to the extent of passing such directions. So I am inviting, commending this honorable court, under 142, your lordship will combine the jurisdiction of parents' patria as well, while exercising this jurisdiction under 142 to dissolve a marriage and on the ground of irretrievable breakdown, please take that into consideration that the child's interest and the family's interest as well is concerned as a parent's patria, my lord. And thirdly, my lord, that
Your SLP is tagged with this?
it got tagged, my lord, actually. It got tagged. It got tagged.
In a way, factually also we'll have to deal with it or not?
Sorry?
It may go back to division bench.
It may have to, my lord. In fact, my lord, just let me bring this the notice of this honorable court, my lord. It is from Bombay High Court, my lord. Justice Oka is also a party to the impugned judgment, where Justice Oka would say, my next submission. The next submission is that, as your lordships had also observed, society has evolved, but law, my lord, has not been able to catch up with the level of, my lord, the advancement that has taken place today. In fact, today, my lords, the society is contemplating a same-sex marriage. The society has already gone into living partner relationship, which is recognized in terms of law. But, my lord, whatever, this honorable court has been able to travel farther and faster than the legislation sometimes, my lord, like in the case of Vishaka. Your lordships passed a direction in 1997 for taking care of offences of sexual harassment in workplaces, my lord, and passed certain directions till the legislation come into place. But it took that 16 years for the legislation to come into place, my lord. So therefore, I'm only saying it's something, Save Life Foundation, where Good Samaritan notifications were in place which were not coming into operation. This honorable court has gone a step further and then passed certain directions, my lord. Now, I am inviting your lordships to go through the provision 13B, mutual consent. In 142, while exercising this jurisdiction, my lord, your lordship will be only furthering the grounds which are already enumerated is my humble submission, because 13 contemplates certain grounds. My lord, 1A of 13 contemplates judicial separation for 1 year, and then, my lord, restitution of conjugal rights, which when it is decreed and not effected for 1 year, it gives rise to a right to go back to the court for divorce. My lord, by the time when they come here, after a restitution of conjugal decree and they keep waiting, it's more than 1 year. It's at least, my lord, 3 to 4 years of waiting. Would we be advising them to again go back and then say there is a restitution of conjugal rights decree against you for 15 years, which is pending? No, now you go and file a fresh divorce petition. Lord, is it not in complete justice that your lordship will be exercising the power under 142? So these are circumstances where, Lord, your lordship can very well read 13B, mutual consent, which says without any ground whatsoever, two people can go to the court and then say we have got irreconcilable differences, we want to part ways. So why not, this irretrievable breakdown can be extended to other grounds which are enumerated in section 13 as well. Irretrievable cannot be a ground as such, Lord, I agree. But when you read as such grounds of cruelty, desertion, or whatever instances which has taken place over a period of time, that as a bundle, Lord, forms a ground of irretrievable breakdown, which your lordship will not then take that into consideration while exercising powers under 142, my lord. Your lordship may kindly see this court, my lord, has gone to the extent of even, my lord, reading down the definition of rape by saying that, my lord, a rape, whether it is committed even by a husband for a girl who is between 15 to 18, can be still considered as a rape, though that part of the legislation was read down and then it was removed, my lord. Though the court says we are not legislating in that judgment, independent thought, Lord, Justice Lokur would write that though we are not, Justice Deepak Gupta and Justice Lokur would write, Lord, though we are not legislating, but this is actually amounting to reading it along with the POXO Act, so that to make it workable, two legislations are workable. Similarly, my lords, your lordship will exercise your lordship's powers to make this, Lord, what the 1976 amendment contemplated is to make divorce liberalized, which they didn't pursue thereafter, my lord. After 76, there is a complete standstill, though there is, though the two law commission reports are there, though there is an amendment bill which never saw the light of the day, there were joint parliamentary standing committee reports, my lord, that nothing has been followed. So all that is there. So nevertheless, my lord, your lordships can read all these into the grounds of the divorce and, my lord, 13B as well. And kindly take that also the parents' patria as well. Lord, today, your lordship will also notice and take judicial notice of the fact, like Ms. Desing also said, Lord, when we talk to youth about marriage, they say it's a noose around the neck and there is no escape route when there is a problem. So therefore, they take to the root of the institution of marriage, which we are all saying that we are wanting to protect, is not getting protected only because, not certain elbow rooms, like they call it, it's a fabric of the marriage is a fabric of the institution. Marriage is a great institution, which is a fabric of the society. Not that fabric doesn't need always 555 soap. It also needs a little comforter once in a while. So therefore, my lord, I think it has to be, my lord, attended to, and your lordships are clothed with ample powers under 142. Now, there are certain judgments which were not read out, which I have put in my compilation. Just one judgment which is very recent, which is even said to the level of saying that, though there is no cruelty made out, still only on 142 we are exercising this irretrievable breakdown is there in the marriage, so we are exercising 142.
That we have said it has been exercised.
In Rajendran, it said over and above that. It said there is. Your lordship may kindly see that tag number 3 of, sorry, it's 4 of my compilation. 4. Yeah. Kindly see this, my lord. Tag number 4. The last few paras would very definitely say that, my lord. It follows, my lord, your lordship judgment in Shiva Shankaran, and then it's in para 35. It would say that, my lord, that the judgment is followed. And para 33 is the, but 33.
They affirm the judgment but exercise 142.
Yes, ma'am. Para 33 is what they are exercising article 142. However, they say that para 29, they are saying there is no merit at all, and therefore there is no argument that they don't sustain. They say there is no cruelty, and every marriage cannot be on that ground, it can't be. Nevertheless, they find there is a subsequent marriage.
What is it?
That is this Rajendran law. And the judgment is on that marital rape. The recent judgment, I think it is, or today, it's pronounced today, is that, this honorable court says, in fact, for a girl who wants to abort in an unmarried relationship, should actually extend, they have interpreted it to me, it should extend to the married relationship as well, where there can be a marital rape. The right to abortion should be permitted to be exercised. So therefore, the extent of powers of this honorable court to mold the relief and to suit the circumstances and to suit the society's development. Yes, today, it's pronounced, we'll pass it on to the court. We'll pass it on. Deeply obliged.
Different perspective, is there a statutory bar?
And just one thing, from case to case, it can be exercised.
Yes, so you are opposing her in her matter, correct?
Not only on the legal issue.
You are saying it should not be granted.
I am saying that independent of the grounds, it can't be granted.
Can't be granted. So that is what.
For the irretrievable breakdown also, we'll have to fit it in one of the grounds. And there is a bar under the Family Act, the Hindu Marriage Act. Just point out, according to me, why there is a bar.
Yes.
That this court, if there is an express bar, then this court can't grant on the ground of breakdown of marriage beyond repair, if there is an express bar. And I would treat section 23 as an express bar. So let's just 2 lines of section.
Yes.
Please. 18 proceedings, 23(1). In any proceeding under this act, whether defendant or not, or non-travelers also can't get a judgment, you have to prove your case, whether defendant or not. If the court is satisfied that any of the grounds for granting relief exist, so grounds which are mentioned in the section 13, if they exist, then only you can grant. That is one. Then there is another provision. Lordship will see, my lords, section 23, 1E. There is no other legal ground why relief should not be granted. Then, and in such a case, but not otherwise. So there is a negative aspect also.
Okay.
So not otherwise you can't grant. And my lords, in my respectful submission, if you are granting on the ground under Article 142, kindly fit into the grounds of cruelty or any other grounds which are already enumerated under Section 13. And what Mr. Giri pointed out, one judgment, not following that judgment, kindly giving a citation, which is in my written note also. 2013, Volume 5, SCC, page 2 to 6. This court held that if for any reason, if a party is not agreeing for a divorce, then in exercise of mental cruelty, it can be granted on the ground of mental cruelty.
One line, which I wanted to say is the consent of a party who is not consenting has to be inferred by their conduct, and it should be read into it.
of you are in a primacy, so colored by your facts. Are you there before the other?
Yes.
My lords, a short note. We
I'm
have
saying,
already.
since the question is whether
Notice there was there.
But I had also filed the written submissions.
Yeah.
Yes.
My lords, kind permission, I am appearing on the lead matter, my lords.